All right, everybody. It looks like we are back. The court appears to be back in session. Let's give everybody, hey, Jeff, good to see you. Let's give everybody a couple minutes just to rejoin the group here. I don't want to leave anybody behind. We've been waiting 8 days now, 8 court days for this, what appears to be the final day of the Robert Tellis trial. So, Jeff, I hope you bear with me for a bit. Let's give everybody a couple minutes. I don't want anybody to miss the final throes of this jury trial. The jury has to sit through a little bit more testimony here. We've been waiting for the final witness apparently to show up in court. And apparently that witness has arrived here, Jeff. And it looks like the court will be hearing from that final witness. In the meantime, while we're waiting on a couple more people to arrive, let's hear. We were talking about this guy and, you know, the vanity of this guy with respect to his shoes and wanting to, at least at work, kind of raise his height from 5 feet 6.5 inches tall to slightly higher, so he gets these non-name brand shoes, these generic shoes to do it. Let's see a little bit more about who this guy is. Earlier in this whole case, he asked the court if he could be given some better accommodations. What's going on, Trey? Good to see you back. Yep, they are flailing. They are definitely flailing. But he's requesting, he's been arrested for murder. He's in jail and he wants better accommodations. Let's hear what he has to say about his better accommodations and see how the judge dealt with that.
Employees at the detention center can engage in cruel and unusual punishment unless it infringes upon the rights of a protected class. And that's just absolutely not correct, Your Honor. And
okay, what specifically are you seeking from this motion?
What I'm seeking at this point, because again, really what they've done is, well, I guess we want to get into it. At this point, I am seeking to have the sheriff speak to the administration at the detention center to open a dialogue about moving me to an area that better suits my safety, while also, you know, giving me an opportunity to engage in more research and also more recreation time. I was in that situation for about a couple weeks before an informant raided my personal papers, and there's again no reason to not have me in a situation like that. I've gone ahead and included in my reply proof that the move was not made for my safety. It was really made, it was a temporary situation, basically made permanent because I annoyed classification with my request for status. And the response in my reply demonstrates that, Your Honor. So again,
Okay, so at this point in this case, this is well before trial, he has gotten rid of all of his attorneys and he's representing himself. And when he was telling the court, look, I want to represent myself in this case, this judge gave him more than ample opportunity to change his mind, told him all the reasons why it was not a good idea for him to represent himself. And during the course of that dialogue, she tells him, look, you're going to be in jail. Your defense attorneys on the outside are going to have access to legal libraries, computers, the ability to conduct research that you're not going to be able to do while you're in jail trying to represent yourself. And Mr. Tellis said, I understand all of that. I still want to represent myself. The judge let him do it because she has no choice. He's here telling the court, I need better accommodations so that I can access research in order to help my defense. So let's fast forward because the prosecutor is going to say some things here. And then let's pick up back with Mr. Tellis talking again.
Here, I think we might want to continue this so she can read the reply.
Now you want some.
I don't need to continue it.
Okay, all right, anything further?
The prosecutor said, I never received his reply. Prosecutor has already said, but I don't need it. I stand on what I've already written. I don't need to read his reply. Basically, I'm sure there was nothing useful in there. I don't need a continuance. He's asked for a continuance on the behalf of the prosecution. She says, I don't need a continuance. So this is the tail end.
So all I'm asking again is that we open a dialogue to see about other means for housing that are less restrictive. That's it.
Anything else? Okay, so this time the court's going to deny the motion. Obviously, you
Deny.
speak to the jail and the people in the detention center about your classification, but the court is not going to tell the sheriff how to run his jail. We have one more thing.
The court is not going to tell the sheriff how to run his trial for murder. And he's trying to convince the court to order the jail to give him better accommodations. This is the 5'6" man with a Napoleon complex, such that he has to elevate his height when he goes to work because he likely feels like it will give him the appearance of authority. The court's back. It looks like we got a lot of people back. Tread, good to see you. Jeff, good to see you. Wesley, you're new here. I'm glad you're joining us. I haven't seen you here before today, but I'm so glad you're here with us. Mortal Clown, Brett, good to see you back. Natalie, you're here. Miss Carol, you're here. Let's get started. Let's see what's going on in this case.
Detective, you understand you are still under oath?
I do.
Okay, thank you. You can have a seat if you'll just state and spell your name for the record.
Once again, first name is Matthew, M-A-T-T-H-E-W. Last name Hovanes, H-O-V-A-N-E-C.
Thank you.
If I may approach.
You may.
Detective, I'm showing you it's been admitted as defense exhibit L3.
Yes.
Showing you it's been marked as defense proposed exhibit 03. 03, I'm sorry. It's been marked for admittance on Q3 as well as R3. And this time we can move for admittance of these. Objection.
Okay, they're all related.
Just have a couple questions for you.
Yes.
In reference to exhibit 03, you can see that this, on page 1, that this is an extraction report from a virtual image produced by you, I mean, your forensics examiner, correct? In this, and you testified previously in this case.
Not sure what you're referring to as a virtual image.
The photographs. Recall the photographs.
Oh, am I
concerning
might
Popeyes.
be looking. You said 03?
Let me ask you this. I'll just back up. This is a report generated from the Dell Optiplex.
These are two reports here that were generated from data that I extracted from the Dell Optiplex, yes.
You can see that it was logged into with a personal Gmail account, correct? That'd be page 4. rrtellis@gmail.com.
There has been a Chrome login with that email address, yes.
This was the same account used on the Android phone that you had given testimony to or concerning previously.
If I had that extraction, I could verify that, but I don't have any reason to not believe you.
Okay, and that's consistent with your prior testimony concerning the cell phone.
Okay.
Is it fair to say that that means that anybody, and we have a work computer and then we have the cell phone. Is it fair to say that this means that anyone in or out of the public administrator's office with access to this computer could also access the same Google account that the phone was syncing to?
I'm not sure I understand that question.
I mean, they're synced, and if a person, obviously, the Google account that the cell phone had access to, it was accessed also from the work computer, or able to, the one that was recovered from the public administrator's office.
I have nothing in this report to show me his phone was synced. I just have an artifact here showing me a Chrome login using a specific email address.
Okay, and if I told you that's the same login address that was used from the cell phone, would you have any reason to disagree with?
No.
And again, not claiming, you were asked previously about hacker information, but if you have this access from the public administrator's office, from the desktop accessing the Google account that the cell phone had access to, it's fair to say that one could access that Google account from either location, from the cell phone or the desktop that was at the public administrator's office.
It would be possible to log into the account from both locations.
If I could turn your attention to Q3. You recall that line of questioning previously and the previous day that you had testified concerning all the images?
I do.
The alleged surveillance images.
Yes.
This shows, and if I represented you, this was the last snapshot being taken. It was on 8/15/2022 at 10:32:48 a.m.
That is what it's showing as a modified time. That's not necessarily the time the picture was taken.
Okay. Do you have any information concerning what the last access, and the last access doesn't necessarily mean that it was changed in any way, but that's what we, based upon your testimony previously, that's about the time that this was taken or it was accessed.
So on here, it has a modified timestamp. That's the last time that the phone interacted with that photo. It really doesn't have anything to do necessarily with when that photo was taken.
Okay. If I could turn your attention to what's been admitted, R3. If you could turn to page 18. Here we have there's a record of time of somebody accessing the Ariana Payne's employment probation completion. Do you see that?
I do.
And do you see that time being accessed at 10:44:29 a.m.?
I do.
Presumably that was from the desktop from the public administrator's office as well as the time that was accessed, correct?
That appears correct.
And if we could go to page 11. You see that? You can see that as you can see, the first access is at 10:43:13 a.m., correct?
First visited date, time, yes.
In reference to the questions concerning deleted images, if I may approach. You were asked questions concerning the Celebrite extraction of the subject cell phone, the one belonging to Mr. Tellis. Do you recall that?
Yes.
Again, during the break, you didn't examine the actual cell phone, correct?
No.
You had been provided a photograph, it was a picture taken, it was up from the Celebrite webpage, and it had discussed deletion, correct?
Correct.
Would that deletion necessarily concern the content, or would that deletion concern the metadata, or both?
It could vary, could be both.
So the metadata is basically the data concerning the data on the phone. Is that a fair?
It's data about data, yes.
And in reference to this exhibit, it was the timeline extraction, correct?
Correct.
And if you could please explain to the jury what a timeline extraction is versus an SMS or a text message extraction.
So a timeline extraction basically takes all the artifacts that were parsed out by Celebrite and just puts them in a chronological order by date and time.
And you're obviously able to access various information through this timeline extraction.
I'm not sure what you're asking there.
This timeline extraction, it contains more information, different information than, let's say, the Teams or SMS extraction. Fair to say?
Not necessarily. The timeline is just putting everything into order by date and time.
And there is an extra column on this timeline extraction contained within this exhibit, Exhibit L3, where on the right, and you did see this, correct?
Yes.
It says deleted, and it says yes, correct?
I would have to see that again.
Absolutely.
That is correct.
Permission to publish this. So here in this right column, and it's, you can see, everybody see that? Up here we have deleted, and it says yes, correct?
Yes.
And there were a number of questions made yesterday concerning a message that was sent to Mr. Tellis's phone. Message being 103602. And there was questions posed to Mr. Tellis concerning having deleted that text message, all right?
Okay.
I'm just telling you what testimony was today. Based upon this timeline extraction, where when a matter is deleted, it says yes. Here, we don't have the red letter stating deleted yes, correct?
Correct.
Same thing as to 3, the instant messages, deleted, we don't have yes, correct?
That's correct.
Thank you. I have no further questions.
Mr. Hannigan?
Through that entire line of questioning.
Just want to cover quick topics. Publishing and through defense and 3. You remember those questions on cross-examination? You were shown this property report and you were asked if you had searched for recipes in any of these devices. Do you remember that?
I remember being asked questions about the other devices, yes.
Okay, so if you could, sir, do you see where it says remarks here?
Yes.
Can you read that sentence for me?
Item 1 was taken from Lee Kinnett's cubicle. Items 2 through 6 were taken from Tellis's office.
Okay, so these were objects. You didn't search for the term recipe or fried rice in relation to digital devices removed physically out of the public administrator's office.
I've done no searches on the other devices.
So like you didn't go through desktop computers to look for recipes?
No.
Okay, but all of that stuff came physically out of the PA's office?
Yes.
It didn't come out of Mr. Tellis's home?
No.
Do you remember there being some question about whether if you have a login that connects to an email, that somehow that links a phone to a computer, something along with, do you remember that?
Yes.
Okay. Just to be clear, you said that that's not what that necessarily means, correct? That's not what that stands for?
That's correct.
Okay. And just to be clear, there are apps or softwares or programs that sometimes require an email address as your username, right?
That's correct.
It doesn't necessarily mean that the data will show up on another device. It just means if you want to access that particular website, you could, you type in your email and then maybe a password or something like that.
Correct.
Okay, and in this, on those documents, it appears Mr. Tellis's Gmail account is maybe the username.
It does.
There was questions about, I think there was one of those street surveillance images, there was a report on that.
Yes.
Okay. Just so we're clear, you on direct and I think on cross talked a little bit about the difference between when the report says modified versus created, right? You've
Yes.
had discussions with this jury about that. What is the difference if you see in an extraction report where an image is created versus modified? What's the difference?
So when the image actually has a full complement of metadata, you might get something like the created time when that picture was actually taken, when it was created. In this instance, with a modified time, that's the last time that that phone interacted with that file for whatever reason.
And I think we've had a lot of discussions about the pathway of a lot of these images being located in what, a cache file, is that right?
Cache files, yes.
What exactly, again, is a cache file?
The cache file is just storing data about these files in order to help the phone speed up processes later on.
So you could, in theory, create a photo, delete that photo that would have had the creation metadata, but if the image was stored in a cache file, that image would just still stay in there, correct?
It would.
Okay, and so when we're seeing modified, you said that's the last time your phone is interacting with the image in the cache, right?
Yes.
And again, the phone has this cache file because it does what? Does it shrink sometimes images down so they're easier to send or things like that?
It can change the size of them just to make it easier to recall that image later.
Okay, but that's the significance of modified, right?
Yes.
There were some questions again about the where are you message. Do you remember being asked that on cross?
Yes.
Just to be clear, you can't speak to definitively if it's been deleted or not. Isn't that correct?
That is correct.
And just to be clear, I'm going to publish L3, defense L3. In some instances, when there's this column here that says deleted, some instances Celebrite can actually capture when a user deletes an image, correct?
Delete some message in this case, yes.
And that's kind of what records that, correct?
Yes.
But there are instances where things are removed from a phone and it won't pop up in that column, is that right?
Correct.
And I think you even had the little printout from Celebrite that explains that as well, correct?
Correct.
There were some questions about the distinction between timeline and Teams messages or SMS messages. Do you remember that?
I do.
Just to be clear, if a phone contained SMS messages, and maybe, you know what Microsoft Teams is?
I do.
Okay, let's just say for a second, a phone carried Microsoft Teams messages rather than, let's say, a desktop. But let's say the phone has Microsoft Teams message, SMS message, maybe multimedia message. If all of those categories were in a phone, and you went to the timeline, if it had timestamps on those messages in all those categories, would timeline just simply put it all in cron order?
It would.
Does timeline in any way manipulate or change the data that's in the phone?
No.
It just puts it in chronological order.
Yes.
I have no further questions.
Anything else, Mr. Dressage?
Yes, just so we're clear then, in reference to the images, and there has been testimony elicited concerning these images near a Popeyes. Based upon your testimony, we can't say when those photographs were taken.
I cannot.
So then to say that they were taken in August, we can't really say that, can we?
I cannot.
So if there was a line of questioning elicited from witnesses yesterday that they were taken August 15th, we can't say that, can we?
I cannot.
In reference to the messages, and there's been questions asked previously concerning deleted or not, that perhaps Mr. Tellis had deleted this message from a family member on the morning of September 2nd. We can't say then, based upon your review of the data, if they, in fact, that question or that email had been, or text had been deleted, correct?
No, I cannot say that.
So it would be wrong to then assume that it had been deleted since we don't know.
On my end, yes.
And finally, I was asking if we could get, I have the things, but I'm not sure where it is. If we can search it. There were multiple devices seized from Mr. Tellis's home, correct? Electronic devices.
You said from his home?
Yes.
Correct.
We had a Lenovo laptop, model 80SA. You aware of that?
If it's on the property report, yes.
We have a Dell laptop,
Sounds, there were quite a few items seized.
and there were quite a few electronic items seized, correct?
Yes.
There was this Toshiba disk drive, card adapter, but we have at least 2 laptops, correct?
You say it's correct off the property sheet, yes.
Did you search those to look for the rice recipes or chicken and rice recipes concerning the questions that you were asked before the
I have
judge?
not searched any other devices, no.
You did not.
I did not.
Thank you. I have no further questions.
Anything else from the state?
One question based off of something you mentioned. He said, remember that question, it'd be wrong to assume that like the where are you message was deleted, right, by Mr. Tellis. Do you remember something
I
along
do.
those lines? But just to be clear, even though you can't definitively say it, you can't rule it out as a possibility, correct? It's possible a user could have deleted the message.
That is correct. I can't say one way or the other.
Okay, thank you. No further questions.
But then to argue that it has been deleted, that would also be incorrect, correct?
Again, I can't say one way.
Right, argue is different. I mean, if you want to ask him his opinion,
You can't say.
I cannot say.
And we wouldn't be able to say unless we had the actual physical phone that was taken from Mr. Tellis, correct?
Even having the actual physical phone might not lead to that information.
Okay. But then to assume that if we have it on an Apple Watch and not have it on this extraction, we can't say that it was deleted, correct? Because this is just the extraction.
This is just an extraction of this specific device.
Thank you. No further questions.
okay, anything else for this witness? Okay, it looks like we have a question.
So it looks like the jury's still paying attention, even though we're at the tail end of this thing. That's good to know. Again, we still like it when the jury pays attention. There could be exculpatory evidence presented at any point. Hopefully we get to hear their question. The counsel for both parties has to agree
Question from
that
the jurors been
the
marked as
question can be
Exhibit
asked.
22. If someone airdrops pictures, would you know if the pictures are on the phone due to an airdrop? And if so, can you tell who did the drop of the pictures?
I don't have a lot of personal experience investigating that specific question, but in this instance, you wouldn't, just taking this phone as a Google phone wouldn't be AirDrop compatible. That's an Apple function.
Thank you. Any follow-up from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Okay. Thank you very much for your testimony here today. You may step down. And you are now excused from your subpoena. Thank you very much for coming back today. Does the state have any further witnesses that they intend to call in rebuttal?
No, Your Honor.
Okay. And Mr. Draskovich?
No, Your Honor. Thank you.
Okay. All right, at this time, ladies and gentlemen, you have heard all of the evidence that will be introduced in this trial. We are going to conclude for the day. When you come back on Monday morning, You will be instructed on the law, and then both sides will be permitted to speak to you in their closing argument, and then you'll be excused to deliberate upon your verdict. I just want to make sure, is 9:30 okay with the parties Monday? All right, so we are going to start Monday morning at 9:30. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice.
So we're done. So Brett, you were saying that you thought the recipe thing had to do with the cut on his finger. It looks like you were right. I'm a little unsure how that ties to the cut on his finger, but the fact that he didn't call a witness that brought those recipes back to that kind of explained this recipe testimony, it appears that it has to do with the cut on his finger, like you were saying. I don't recall that testimony. Did he say that he was preparing something? I know that he was preparing a meal for his daughter when he allegedly cut himself. Was he cooking Chinese food at the time? Is that why we had all of this evidence about recipes and fried rice and Chinese food? I missed all of that. I was waiting for a bombshell here. I was waiting for him to go somewhere totally different. And apparently we already have all of the information that we need. Maybe he'll pull it all together in his closing statement, explain it to the jury, because I would guess that if we're guessing, the jury might be guessing as to the relevance of all of that recipe evidence as well. I don't know. So this is the first time that I'm stumped with respect to what the state was trying to prove here. I don't think that any of this, the tail end of any of this, though, was helpful to the prosecution or the defense, and hurt the prosecution or the defense. It seemed like we just kept getting a repeat of kind of the same line of questioning over and over with respect to whether or not that text message had been deleted, could have been deleted, what have you. I would anticipate, though, that in the closing statement, in the state's closing statement that we're going to hear on Monday, the prosecutor is going to essentially tell the jury, look, regardless of whether or not he deleted the text, the fact still remains that his wife didn't know where he was. So, and that's a problem for him, right? Because his wife should know where he is if she's at home and all he's doing is going for a walk. So I expected that that's going to come back. But with respect to whether or not he deleted the text message, I think they both sides just have to kind of leave it up to the jury. What do you think? Do you think that this guy was lying about that? And based on all the testimony, it's like Robert Tellis wants the jury to believe that everybody else, every other witness that took the stand was lying because they were involved in a conspiracy, not only to kill Jeff Gehrman, but to frame Robert Tellis for that crime. So don't believe any of these witnesses who you all have said are extremely credible witness. Don't believe any of them. Believe me. And I didn't delete that text message. So I don't know. I don't think that the defense presented enough to cast reasonable doubt. If I'm on this jury, I have no doubt in my mind. The fact that it's possible that this massive conspiracy could have happened doesn't do anything with respect to whether it actually did happen. And you have to give, in order for the doubt to be reasonable, the jury has to be presented with something, some shred of evidence that this conspiracy theory that looks like it's been concocted whole cloth by Robert Tellis actually existed, that there was this massive conspiracy. And we have, correct me if I'm wrong, but we haven't seen any evidence that anybody was conspiring with anybody else. And that's essentially what all of Mr. Tellis's hopes are pinned on. If he has any hope for himself, you know? I mean, at some point, he obviously didn't have any hope for himself. They found him in his bathtub. That's where he was when he was arrested. He was inflicting harm on himself. And yeah, exactly, Movie Mood. That's a lot of people that would have had to come together, concoct this entire plan, and then keep the whole thing a secret. A whole bunch of the members of that conspiracy, a whole bunch of the co-conspirators would then have had to take the stand. And everybody who's been watching this, at least everybody in this chat, would have had to find all these witnesses credible, even though they're holding back all of this information. And not a single one of them, not a single one said anything that would have possibly pointed to them being a member of this massive conspiracy. That's a big secret to keep in when you're being examined by the prosecution and then being examined by the defense attorney and then being on redirect, examined again by the prosecution, and recross, being examined again by the defense attorney. To be able to keep all of that a secret, it's mind-boggling. And these witnesses were credible. A lot of these witnesses were credible because they were saying things that didn't necessarily point to Robert Tellis having committed this crime. You saw it right here. This guy saying, yeah, there's no way for me to know whether he deleted this. I just can't know one way or the other. He has to know that that hurts the chances that Robert Tellis is going to be convicted of this crime. But he's telling the jury, look, this is, I have this report, and this report doesn't give me the information that you're asking me if it gives me. I can't know the answer to that question. Liars definitely can't keep their story straight. And it's because they have these two warring things going on in their head. They have the truth over here that they have to suppress, but they have to let enough of it out to commingle with the lies that they've concocted over here. So it just has to mix enough without mixing too much. And treading that line is extremely difficult. And you may be able to do it if it's one person. You can possibly do it if it's two people. But according to Robert Tellis, this conspiracy involves at least 10 people. At least 10 people. And a whole bunch of those people took the stand. How could all of these alleged liars have kept their story straight? I don't think it's possible. I don't think the jury thinks it's possible. I don't think you all think it's possible. And again, there's no reasonable doubt in my mind that Robert Tellis committed this crime. The evidence against him is there's too much. It's too much. His explanations of the evidence are too poor. In one instance, he's saying, I don't have name brand shoes because I can't put risers in them. And the next minute, he's saying, but yeah, I did have Nikes that look just like the Nikes that were used in the commission of this crime. But hey, somebody hacked my phone and saw that I had that picture in there. And that's why they used those Nikes when they were committing this crime. And or you all have withheld all of the surveillance video that you have of me, and in some of that surveillance video that you withheld and that the jury hasn't seen and nobody's seen, you saw me walking around in that particular pair of Nikes, which is the only pair of name brand shoes I got because I don't buy name brand shoes. You all saw me wearing it, and because you all are involved in the conspiracy, you all told Compass Realty, and Compass Realty told the assassin they hired, and the assassin that they hired picked up a pair of those shoes and wore them the day that he committed this murder. And that's what happened. It's just too unfathomable to be believable. This is a mind-numbingly complex conspiracy. And in all of the efforts that these conspirators allegedly took to bring this conspiracy to fruition, not one of them had the bright idea of, you know what? Why don't we put the murder weapon in his house? Why don't we put this orange shirt in his house? Why don't we smear his car with the victim's DNA? Surely that'll get him convicted. And that's what we want, right? The whole purpose of this entire conspiracy is to get Robert Tellis to go to jail for the rest of his life. Not one of them in this complex conspiracy decided it would make so much sense for us to just plant the best possible evidence in this guy's house. But I'm just some guy. What do I know? Right? Look, guys, we're going to get closing statements here on Monday. That'll be day number 9 of this trial. I am glad that the witnesses are done, that we are done hearing evidence. I really want to see, hopefully, Chris is the one that puts on the closing statement. I was a little more impressed with Chris than I was with the other district attorney. And I'm really hoping that he wraps all of this up for us. Not that DA Weckerly did a bad job. Not at all. I was just a little more impressed with DA Hamner. And hopefully he wraps all this up for us in a nice little package that's easily ingestible by the jury. It's going to be impossible for the defense to present a nice, neat little package for the jury because it's a massive conspiracy, apparently. And I don't even know that the defense attorney weaves that conspiracy into it. He doesn't seem convinced that there's a conspiracy at all. But regardless of what happens, I do hope that all of you join me on Monday to hear the closing statements from each side. And hopefully we get a verdict. because I don't think it should take long. I don't think it should take long at all. I do appreciate all of you joining me up to this point. I have taken copious notes. I don't know nothing about this fried rice though. So if you all have questions about stuff, drop it in the comments. Please don't ask me about the fried rice. I have no idea. They lost me with the fried rice. They lost me. Ask Brett. I think Brett knows. Brett knows about the fried rice. Anything else, if you drop a comment about any questions you might have about any of the testimony from any of the days, I pretty much have half a notebook full of notes on this entire case. I'm sure I can go back, refresh my memory as to what occurred and be able to answer your questions. And I'll do that before we all come back here on Monday for opening statements. That's going to be at 9 a.m. Nevada time on Monday. That'll be noon. For those of us on the East Coast, again, I appreciate all of you joining me. Thank you so much. I have thoroughly been enjoying this. I've been enjoying chatting with you guys. I've been enjoying answering your questions. This has been delightful. I'm sorry that we're doing this under these circumstances. And I'm sorry that Jeff Gehrman's family has to endure all of this. And they don't have the ability to be able to endure this in quite the manner that we are. We are able to do this in kind of a lighthearted, much more lighthearted manner than they are. I truly feel for his family. Hopefully they will have some closure with respect to this come next week. I hope to see you all here. But for now, as always, my name is Nathan Saunders, and this is The Legal Good.